This is Adrienne Batcher in for Jerry Agar here on In-Depth Radio News Talk 1010. Well, a judge in the state of New York has recently released an order that is telling Twitter, of course, everybody knows Twitter now, the 140 characters, and you can tell the entire bloody world how you're feeling in 140 characters or less. A judge has ordered that the messages from a protester during the Occupy Wall Street movement need to be released. Now, previously, Twitter, and of course, this incited the anger of the American Civil Liberties Union. No shock there. That Twitter has on their user policy that that when you tweet, when you send out your thoughts to the world, that is you own that. That's your ownership. Now, the judge is suggesting that no, that is not the case, that Twitter has to turn over to prosecutors a message that was sent by a Brooklyn writer during the Occupy Wall Street protests last fall. And by doing so, the judge has indicated that although private speech is protected, the same did not apply to public comments on Twitter. So joining me is Edward Prutschi. He's the legal expert from CrimLawCanada.com. Edward, you've seen this story. You've seen it's risen the ire of all those civil liberty types out there who think that you put anything out there on Twitter and that there aren't going to be any consequences for it. What are your thoughts on the ruling?
Well, I mean, honestly, I'm a little bit surprised by the surprise that has come through all of this. It seems somewhat obvious to me that when one is using Twitter, and I'm an avid Twitter user myself, if you're going through the process of trying to broadcast to the public and to your followers, and people brag about how many thousands or tens of thousands of followers they have, the corollary of that is that what you're saying there is effectively public. Now, you can retain ownership of it, as Twitter says, so that what you say is still something that belongs to you. But it doesn't mean that there are no consequences to what it is that you say, and it doesn't mean that the government, in this case the prosecutors, can't come back and utilize your own words in order to prove a case against you. Right.
So this is just one more step in, and I keep seeing this thread of personal accountability and everything that we should be doing in our lives, because we've seen broadcasters lose their job on things that they put on Twitter. We've seen politicians get themselves into really big trouble for things that they put on Twitter. We've seen even recently in France, the first lady or the first girlfriend, she put something pretty negative about the former her current partner's spouse on there. And so there has to be some degree of responsibility. Clearly, in this case, with respect to the guy who tweeted in the Occupy movement, the prosecutor sees something that he may have put up there that could contradict some sort of testimony.
Right. Well, I mean, in that specific issue, the issue that the prosecutors are looking at is where he was at particular times of the day and what instructions he was being given by police, because this is actually a relatively minor case that has developed into this very large civil liberties question. But the issue was whether essentially a sort of public mischief ticket that was going to be issued to him for protesting in a place that he wasn't permitted to protest, whether that's going to stand. And the prosecutor believes that messages that he put out on Twitter will indicate both where he was at the time, what he was saying, and what others were saying to him in terms of why he ended up on, in this case, the bridge at a particular moment. And what people, I think, have to remember about Twitter is that there's nothing unique with respect to writing something in 140 characters and then pressing send so that it goes public, between that and simply speaking your mind. And so just because it's retained longer and it may be broadcast louder, you really shouldn't be saying anything on Twitter that you wouldn't be willing to say to that person's face themselves in public.
Adrienne Batcher from the Toronto Sun in for a vacationing Jerry Agar, but Jerry will be back tomorrow to take all your calls and share your thoughts and opinions with him. On the line I have with me is Edward Prutschi. He's a legal expert from CrimLawCanada.com, and we're discussing the recent ruling in the state of New York, in Manhattan specifically, where a judge has ordered Twitter to release a protester's message. This protester is due in court for what the prosecutors are saying are some incendiary things during the Occupy Wall Street movement. The prosecutors believe that what this person has put up could contradict some of the testimony that they're anticipating is going to be coming forward. Edward, before we took our break, we got into the whole notion of the civil liberties, of this, you can't get any more publicly broadcasted than Twitter these days. I think that we have to sort of step back as citizens and think to ourselves, are these 140 characters going to cost me my job, get me thrown in jail, because it's not as private as you'd like to think anymore?
Well, I think the issue is that you can't have selective privacy, right? Mm-hmm. This is not a situation in which the government is asking to see your personal diary, or they're asking to bug your home so that they can hear conversations that you have in your bedroom. This is a situation in which the government wants to utilize comments that you put out on a public network and distribute it to tens of thousands or millions upon millions of people, depending on how many followers you have, although you don't even need the followers. I mean, as you know, with Twitter, anyone can see anything. Mm-hmm. So it's a question of who just happens to be looking. That's just not a situation in which I think the government and the judiciary are going to have much respect for quote-unquote privacy. It's not private by definition. It's public.
Right. So when and they always fuss me, is the ACLU, the American Civil Liberties Union. It should come as no surprise to you, Edward, that they've gotten involved in this. They have filed what they called a friend of the court brief in the case. They've argued that the prosecutors should be required to obtain a search warrant. I mean, that seems a little excessive to me.
Well, I mean, I understand the argument. I just frankly don't think that it's one that's going to be very persuasive to the court. The American Civil Liberties Union, like many other civil liberties organizations throughout the world and in Canada, are always very concerned, rightfully so, that government is going to be given increasingly broad permission to access private information that belongs to citizens. Mm-hmm. And that's something that we do have to be extremely wary of. So, I'm completely in favor and behind them when they make efforts to secure privacy rights, whether it's something that you do in your personal home or something that you're writing down that's not meant to be public. But I think where they run into a very significant problem is, again, in the social media sphere, where by design a person is saying something for the purposes of it being public in what is a public sphere, just because it's being typed on your private BlackBerry, but then being sent out for the purposes of distribution to the public, you're going to have an awfully tough time trying to, as I say, selectively turn on and off the public nature of that comment.
Right, and it's far easier for the courts to go directly to Twitter, for example, for the tweets that had been deleted from this particular individual. The issue is that he deleted the tweets, and so they don't exist on his feed anymore. But there's also opportunity for the court, if they have to. They can get subpoenas, can't they, from the servers that host all of these various, right. They can go to the RIM server, for example, and get things.
It's a combination of a couple of things when it comes to Twitter. I mean, one is that a person can send out a tweet and then delete it. Mm-hmm. Another is that, as you probably know, Twitter, your Twitter feed is only sort of live for X number of days, depending on how busy one is. So you can't go back months upon months upon months, at least on the public, Twitter.com, and see what somebody said a year ago. However, that doesn't mean that Twitter itself on its server somewhere doesn't have access to what was written beforehand. And so what I think the prosecution wants to do in this case is go back to the Twitter server and basically rebuild that feed and see it again. So that creates a situation in which the argument is, well, that's private. But in my view, I don't think the fact that something is no longer publicly accessible on the web, that doesn't in and of itself make it private. It was said in a public forum, and basically it's just been, quote-unquote forgotten or digitally forgotten. But if it can be recovered, it doesn't mean that you didn't say it.
So now Twitter's rationale, and we have to wrap up quickly right before the news, Twitter's has said that they are disappointed in this ruling. It's going to cause them an undue burden of either turning over the information or fighting each request on behalf of its users. What do you say to them, and what do you say in the long term? Where do we go with this? This will affect Canada as well at some point, too.
Well, first of all, this judgment doesn't have any impact in Canada right now, other than the fact that it's an interesting thing to look at. And when and if the time comes that it's argued in the Canadian court, I'm sure someone's going to bring this up, and a Canadian judge is going to look at that for some guidance.
So there will be some precedent setting at some point.
It's not a precedent that binds anybody, but it's something of interest, and certainly cross-border judicial decisions have a certain amount of respect, and people will look at those to see where that goes. But Twitter's perspective is understandable in that they're now put in the unenviable position of saying we either become complicit in government investigations and basically throw our users to the wolves, or we have to play the role as a corporation to stand up and argue one at a time in every case that this comes up that you're violating the privacy interests or you're violating the personal interests of our own users. It's not the users that will have the heaviest burden of putting up the fight. It'll be Twitter. And I don't know if that's a fight that they want to take on, considering that they've got now tens of millions of users. This could result in pretty significant consequences for them unless they just shift their policy and say, look, if we're asked legally by authorities, we're going to turn it over.
Edward Prutschi, thank you very much for joining me this morning.
Thanks, Adrian.
He's a legal expert from crimlawcanada.com. You can log on and check out all of his stuff.